My Lord, the first time it was considered was 16th of February 2017, when, my Lord, the application was dismissed. Against that, my Lord, we filed a writ petition before the High Court. The writ petition, my Lord, came up before a division bench. The division bench, my Lord, looked into the matter, came to a conclusion that because of the rules as they are framed and the notifications issued by the state of West Bengal, there arose a legally enforceable right. But the extent to which that right must be given effect to was a matter which the tribunal should apply its mind. It held in our favor that there was a legally enforceable right, but it needed, therefore, fresh consideration by the tribunal. Well, that judgment is important because many of the submissions which were urged yesterday were in fact urged in that proceeding, and, my Lord, those petitions came to be allowed. That judgment, my Lord, of the division bench of the Calcutta High Court is of the 31st of August 2018.
Page 368.
That's right, my Lord. That same judgment. That judgment, my Lord, was sought to be reviewed by the state. That review also, my Lord, came to be dismissed.
Page 444.
That's right, my Lord. Then afterwards, we now come to the application coming back to the tribunal, and the tribunal, my Lord, has allowed the original application. My Lord, the various paragraphs which were read, it was suggested that the tribunal had simply overstepped its jurisdiction and had issued some sort of a mandamus, and, to borrow the words of Mr. Divan, something alien to the rules was attempted by the tribunal. It was extraneous, to borrow his expression, to the rules and the notifications. Then, my Lord, the matter naturally goes to the division bench once again. My Lord, there are two judgments of learned judges. Both these judgments, my Lord, have found four conclusions. The first conclusion is on the question of dearness allowance being claimable as a legally enforceable right has been held by the previous division bench, and the matter has acquired finality. That's the first. The second conclusion is that we read the rules as they are framed clearly suggest that in order to adjust against the cost of inflation, the rule is indeed indicative of the fact that dearness allowance would be payable upon revision from time to time. Well, the concurring judgment, in fact, very elaborately traces this entire AICPI IW, for right from the time, my Lord, it evolved in 1944. My Lord, it's quite useful as a historical account. But then, my Lord, what is important is that the learned judge comes to the conclusion that on an interpretation of the rule, both on its own terms and as understood by the government in its notification, this was meant to operate as a time-to-time benefit which had to be given, because the very purpose of dearness allowance is to protect the real value of money. Well, Lord, if one understands this aspect, that dearness allowance is really to protect the true purchasing power which your wages or your salaries are meant to achieve, and keeping in mind the revisions which take place, my Lord, there is an adjustment, and that, my Lord, is not something which is a matter of bounty, nor is it, my Lord, a matter of, if I may say so, a claimable right per se. But if, my Lord, the rules give this as a part of your emoluments, based upon an acceptance of the recommendations of the Pay Commission, then, my Lord, I submit, that becomes a compellable obligation. So, my lord, the right to get existing emoluments reckoned in accordance with the rules is a legal right vested in me by the rules and imposes, my lord, what we call in jurisprudence a corresponding obligation or a duty on the state to abide by that rule. And, my lord, that rule, therefore, can legitimately be the subject of a mandamus. Because, my lord, a mandamus always is in the context of a public duty or, my lord, a statutory duty or a constitutional duty. Here it is a case of a statutory duty which is enjoined by the rule. Now, my lord, may I straight away take your lordships to the first division bench judgment and only 2 or 3 paras to satisfy you that that judgment, my lord, analyzed these defenses. This very same judgment of 1954 Supreme Court, which was cited by Mr. Divan yesterday, that is, my lord, the state of Madhya Pradesh judgment, was also examined, and the court distinguished it on the ground that the words of Fundamental Rule 44, which was being interpreted by Justice Venkatramaya in that judgment, provided for the word may. And because there was the word may, this was a discretion which was vested in the government. So, my lord, this is one aspect. The court also dealt with other judgments and said that the law is, if there is a pay commission, it is not binding on the state government. A state government may accept it, may not accept it, may accept it in part, may accept it in total. Now, my lord, the court, however, says that if it is accepted and is translated into a rule, then that rule imposes an obligation. So then the rule, well, a rule could also permit discretion. Now the question is, my learned friends in their interpretation want to invest this rule with having induced a point A, after which, my lord, there is only a remnant of discretion. And that construction, my lord, is the one which I seek to displace in my submission for your lordship's kind consideration. Because this is, my lord, really the scope of contest. Now, my lord, I will also place those paras of the administrative tribunal. My lord, they were placed, they were rendered, my lord, in a context. The context was that, my lord, the central government was making it a practice to give dearness allowance when necessary, twice a year, because, my lord, twice a year you have the benefit of the discovery of the index. This word average, which your lordships find, is really, my lord, an average of 12 months, which is actually the basis of arriving at that figure 536 in the year 2005. So that is why you have the word average index, because it's over a period, weighted average, my lord, for 12 months. Now, having said that, my lord, let me take you straight away first to the rule and also explain, my lord, that it is time to time, because that is the purpose of the rule. So may I straight away do that, so that we deal with the heart of the matter.
We want to request.
Please, certainly, my lord.
We are conscious of this fact that we were conscious that you're going to argue that the division bench has already settled the issue and they have not filed any appeal, so therefore a judicata would apply. You are aware of that. Now, we would request you for one thing, because it is going to have pan-India functions. You please proceed as though we are hearing it for the first time.
Certainly.
Because we have to lay down.
Certainly, my lord. Certainly. There's no difficulty at all.
That's how we will.
No difficulty at all.
Mr. Divan,
Yes.
Mr.
Yes.
They were focusing only on the rule.
Yes.
So therefore, how do we read the rule
Yes.
to your benefit and advantage is what we want you to address.
Certainly, my lord.
First, and then we'll
Yes, certainly. Certainly.
the manner in which.
Certainly. And, my lord, even if it is pan-India, I'm not, if I may say so with respect, I'm not overwhelmed by it, because even consistent with all the judgments which I'll place, my lord, it is very clear that the law is that dearness allowance is an integral part of remuneration. Secondly, it is vital because the real value of money must be available to an employee of the government. The third is, if it is left to the determination of a pay commission and the pay commission makes a recommendation, it is open to the respective state government to either accept it or reject it. It is not binding, proprio vigore, although there are judgments which say it is entitled to some weight because it is an expert body, but we will leave it at that. But if it is accepted, then it binds the state government. And if it is, my lord, then metamorphosed into a rule under Article 309, then the rule, my lord, becomes a compelling obligation. So this, my lord, is the. Now, my lord, may I straight away take your lordships to the rules?
Please.
And before that, my lord, if I may invite your lordship's kind attention just to see the context of the rules, which is, my lord, please see Annexure P1, which is at page 97. It is a part of the Pay Commission's report produced by the state. That will be printed page 97, my lord.
Chapter 10.
Yes, chapter 10. And PDF will be 137. This chapter 10, my Lord Justice Mishra has that. In this chapter, we have discussed 4 of the most important allowances now available to the state government employees and also to some of the non-government employees covered by our terms of reference, namely Dearness allowance, medical allowance, house rent allowance, and non-practicing allowance. We have not been able to devote our attention to other allowances, including the so-called special allowances that the state government currently pays to its employees, some of its employees. We propose to deal with these allowances in any of the later volumes of our report. Then, my lord, 10.2. Now we first deal with Dearness allowance. Due to the unabated pressure of inflation in the economy, the real value of salary fixed periodically by pay commission gets continuously eroded with the passage of time. Thus arises the need for pay. The state does not suggest that there is no increase in the cost of living. Now, my lord, please come to 10.3. The state government, since the 1st of April 1979, has been following the same principles followed by the Government of India in the matter of calculation of the quantum of each installment of Dearness allowance. But almost invariably, there is a time lag in actual payment, and when the same is paid, the same does not include any areas. Right now, only one such installment has remained, due which the Government of India sanctioned on 1st of July 2008. The last installment, which the state government has sanctioned, is set out in Schedule 1 to the ROPA Rules 2009 relating to services generally published with the notification 1690F. Then, my lord, the various rules and regulations. And then these have been, my lord, published in the Gazette. Now, here, my lord, your lordships will find, please now just scroll over to the most important part, my lord, which is at printed page 166. 166.
Clause 10.
Clause 10. And the most critical part, my lord, of clause 10 is this. Consequent upon revision of... Sorry.
Yes.
This is 166. Consequent upon revision of pay of government employees in accordance with the West Bengal Services Revision of Pay and Allowance Rules 2009, the Dearness allowance which a government employee is entitled from time to time since the first day of January 2006, because that is the date of the Central Pay Commission, 1/1/2006, needs to be related to pay in the revised pay structure. Now, my lord, your lordships may kindly see the crucial words are the Dearness allowance to which a government employee is entitled from time to die since the 1st of January needs to be related to the pay in the revised structure. This is, my lord, in response to my Lord Justice Mishra's question, that how do the three clauses work? Because the word is aggregate first. It is 1 plus 2, on which, my lord, there is 3. Then please see, now this is, my lord, quite important. And this is how, my lord, the rule needs to be looked at. Now we come to the rules. Now please see now, my lord, the rules.
Sorry, 1 minute.
Yes.
The government notification of 23rd of February is at what page?
Yes. That is, my lord, that is the next annexure, my lord, which is 1692F, I'll place of government employees. My lord, that is printed page would be 168. I think there is also a typed copy which has been provided, which is at printed page 170. My lord. 170. It's easier on the eyes. The governor is pleased to decide that the whole time state government
That's something else. That's something.
Oh, sorry.
You have to read from.
Oh, I have to read from that, yes. Yes. I'm grateful. Well, Lord, please therefore come back to 168. Consequent upon the revision of pay scales of government employees under the provisions of the West Bengal Services Revision of Pay and Allowance Rules 2009, it has become necessary to relate, my lord, this expression, to relate dearness allowance admissible to a government employee to his basic pay in the revised pay structure in the case he has elected or is deemed to have elected to draw pay in the revised pay structure prescribed under the aforesaid rules. As has been laid down in Rule 12 of the West Bengal Services Revision of Pay and Allowances Rules 2009, that no areas of pay and allowances to which any government employee may be entitled in respect of the period from 1st of January to 2006 to 31st March 2008 shall be paid to the government employee. The dearness allowance admissible to a government employee needs to be related to his pay in the revised pay structure with effect from 1st of April 2008 only. So, my lord, while the revised pay structure would be worked out with effect from 1st of January 2006, but you will get no arrears. And from 1st of April 2008, that is, my lord, the newly revised pay, you will be entitled to dearness allowance. Accordingly, the governor is pleased to decide that the dearness allowance payable to a government employee with effect from 1st of April 2008 shall be at the following rates. And your lordships will find this 2%, 6%, 9%, 12%, 16% are the percentages given by the central government, although it was with effect from 1/1/2006. So, what is important is that time to time. That is reflected in this very notification itself. 1/4/2009 onwards, it says 16% and it leaves it at that. Now, my lord, let us go to the rule, because this really is the subject of interpretation in our case. Please come to the rules. The rules are, my lord, they begin annexure P2 at printed page 100. And if your lordship sees, basic pay means the pay drawn in the prescribed existing scale of pay, including stagnation increments, if any, but does not include any other type of pay. And then, my lord, we have that expression existing scale. Then we come to existing emoluments. Existing emoluments mean the aggregate of, which is, my lord, it's the total which has to reach an employee. But it has different elements. The first is existing basic pay, that is, my lord, the unrevised pay, dearness pay appropriate to the basic pay, and dearness allowance appropriate to the basic pay plus Dearness pay at index average 536, 1982 is equal to 100. Now, my lord, the use of this word index, my lord, index itself, my lord, it's a Latin expression, it means a pointer. This index is really the pointer. And how do you calculate the Dearness allowance? It is with reference to this numerical 536, 1982 is equal to 100. That is, my lord, 100 rupees of 1982 today is you need 536 to draw the value of 100 rupees which you had in 1982. Now, my lord, your lordships will notice, and that there is actually, my lord, a calculation which I made. It is clear, my lord, from all the rates declared by the central government, they have used this formula, and this formula is the other side as well. This formula, my lord, shows that the denominator is always 536. So the figure 536, which your lordship saw, is critical. Please have a look at this. Please see, my lord, please see for a moment column H. We are now talking of April 2008. In April 2008, my lord, the DA given by the central government was 12%. Does your lordship find that in column C? Yes.
Yeah.
I'm sorry.
Yes.
It was 12% in April 2008. My lord, we got 2%. Then, my lord, the balance was 10%. Now, my lord, what is the formula for calculation of central government DA rate as reflected in column C? It is 605. That is, my lord, 536 had gone up to 605.
Yes. Yes.
This 536, my lord, the AICPI index rose to 605. So, my lord, you divide it by 536 and you also deduct that 100 because 1982 is equal to 100 has already been subsumed. That is how you get, my lord, 12.87. But, my lord, they now forget the decimals. They give it closer to, that is how, my lord, it is done. So each of these, your lordships will find January 2009, 22%, and, my lord, we got 9%, but the calculation in H is 656. Sorry,
No, it's all right.
656 upon 536, keeping in view 100, that comes to 22.39. So that figure, that average index, which says 536 within brackets 1982 is equal to 100, is, my lord, the factor of calculation at each point of time when the index changes. Now, please see the next one, 727 divided by 536, and again offsetting 100, you get the percentage 35%. 815, again, my lord, you get 52%. Then 887, you get 65%. So, my lord, there is actually a scientific, it is almost like an actuarial calculation. Please then turn over the page. In January 2013, the figure, my lord, becomes 969. That takes you up to 80.78%. Then, my lord, in January 2014, it increases up to 1075, so 100.56%. Then January of 2015, it goes up to 1140, central government. Now, if you look at the structure of the rule with me now, look, the words are important. Dearness allowance, the crucial word, my lord, here is appropriate. That word appropriate means it must be appropriate to the basic pay plus Dearness pay at index average 536. So, my lord, this index average 536, if 536, my lord, undergoes a change, then taking into account 536 as a denominator, you work out the percentage of increase. This, my lord, is really the purpose of this particular rule. So, my lord, instead of even taking a position that this is an implicit arrangement in the rule, my submission, my lord, is that this is explicit because it is A, an aggregate, B, it is appropriate to the revised pay, C, at index average. And that in some of them, my lord, were working at the Bonga Bhavan in Delhi, some of them were in a youth hostel in Chennai, and my lord, they were being granted actually the dearness allowance exactly on the basis of the central government rates. Now, that was an additional factor for the court to say that this is a case of discrimination because they're governed by the same rules. And there is no difference, there is no intelligible differentia that they should get a higher. But it was taken into account. But it was not the primary reason for applying. The primary reason is that in the very nature of a dearness allowance, if it is meant to offset, my lord, cost of living increase, the increase, my lord, in essential commodities, my lord, it is done also in a very scientific way by the Bureau of the Labour Ministry. They, my lord, actually get data from the Ministry of Consumer Affairs every month on every item. And, my lord, why they apply industrial workers is they take, my lord, much lesser in terms of that is essentials, basic essentials which are required. But if their prices have gone up, then, my lord, they take data from all over India and make an adjustment. And this adjustment, my lord, like even today, as we speak of yesterday, my lord, the central government for the festive season, but because the AI CPI index went up, gave, my lord, a 3% increase to the employees. Now, what I'm saying, my lord, is that this is on the basis of understanding that dearness allowance is not a matter of race. Dearness allowance is integral for the real value of a wage. So, my lord, if the real value of a wage has to be protected, of course, my lord, if the state of West Bengal, let us say, had a Mahalanobis formula, a different formula to actually calculate dearness allowance, it's very different. My Lord Justice Mishra asked an extremely critical question yesterday. What was the basis on which you changed? What was the working? The working, my lord, for a good part of time was only the central government's, but it was, my lord, postponed, as your lordships have seen. So, my lord, the issue is, if the rule gives this method of calculation, is it not binding on a state government in terms of the emoluments which have to be available to a government servant? In addition to this, my lord,
Can you provide us an exemplar of an employee working at Banga Bhavan in Delhi or at Chennai being paid DA in terms of the central government rate?
Yes, my lord, I have
An exemplar
yes,
of
yes,
any employee
yes, my lord, yes.
who is working
I'll-
at Banga Bhavan vis-a-vis the same cadre of employee getting a less amount of DA if he is working in Calcutta.
Exactly. Lord, I'm showing you the chart. I'm very, I'm deeply grateful. Please come, Lord, to a chart. Yes. Please see, my lord, Annexure CA2, which your lordships will find is at PDF page 895, but it might be printed page 17. It's a part of the counter affidavit of the second respondent. It is an annexure, my lord, CA2. Yes. Of respondent 2, my lord. Between the state government employees working at Bonga Bhavan, New Delhi, and Youth Hostel, Chennai, and West Bengal state government employees working in the state of West Bengal in connection with ROPA 2009 and 2019. Now, my lord, your lordship sees April 2008 is from when, my lord, we were entitled to a pay. 1st April 2008. we got 2%. Is your lordship able to see that chart? We got 2%. Your lordships recollect that in that notification. My lord, Bongo Bhavan, they applied the central government dearness allowance and gave 12. Similarly, my lord, all the payments which your lordships will see in column number 3 are exactly those of the central government AICPL. My lord, this is not even one exemplar. This is continuing from 2008 all the way. Your lordships will find what was it which we got in the last but one column, and what is it, my lord, others who were also governed by the same statutory rules. What did they get? So, my lord, the suggestion by the state that they don't know how to calculate this is certainly not, my lord, because they are the ones who gave this. Please see 27, 35, they followed strictly, my lord, all the way, as your lordships will find, right up to, all the way, my lord, I'm now going to take you right up to 2000 was available in terms of the calculation of that formula for the central government. So this is the point, my lord. And this is not merely a case of incidental discrimination. This is a case where the same employer, for some of its employees, is making available dearness allowance exactly, my lord, ditto of the central government based on this formula. So, my lord, the point which is being made by Mr. Divar, that it was static, it became fossilized on the day, my lord, as I said, in any case, the pleadings, my lord, are in fact inconsistent with this. If your lordship see the judgment of Justice Samalto and Justice Tandon, the two learned judges, nowhere, my lord, is there a suggestion that it stood frozen at a point of time, because, my lord, dearness allowance in its very concept is a variable allowance. This is the point.
Is there any separate GO issued by the government of West Bengal in respect of the Bang Bhavan employees and
No.
GD employees?
No.
I think there is, my lord, judges.
Has been subject to corrections. Page. Annexure 31, my lord, I'm given to understand of the page 31. Please go to page
Of the same one,
31 of the counter
same counter of R2
of R2, my lord.
page.
It's page 31, my lord. Annexure C2. My lord, this is actually with reference to the ROPA rules of 2019.
Or it continues the same problem.
My lord, I want to make one thing clear. These cases are governed by the rules of 2000 and 2008-9. 2009 rules, my lord, are the issue in this case. But even after the ROPA rules of 2019 came, it's important to see, my lord, this very significant point.
No, this happened for the first time in 2019.
But that is because the 2019 rules, my lord, did away with dearness allowance in the rule. So what they did was, they issued this order consequent upon the revision of pay and allowances of state government employees with effect from 1st of January 2020. Under ROPA rules 2019, Governor has been pleased to order that the state government employees posted in New Delhi will draw dearness allowance, house rent allowance, so and so, with effect from dearness allowance at the central government rate. So, my lord, although the new rules abolished dearness allowance, but they followed that same pattern of giving the central government DA in respect of these employees. And, my lord, the 2019 rules are not the subject here today because, my lord, still discussions are going on. The Pay Commission, which dealt with the 2019 rules, my lord, the report was published only 2 months ago. So that is being examined, how to deal with that. Because, my lord, that actually did away with dearness allowance. So notwithstanding dearness allowance disappearing from the 2019 rules, they continued to give my lord, the central government DA,
Presently, they are not getting DA.
where, my lord, they were no, now, my lord, now after a period, that is the new rules of 2019, my lord, they were notified in September 2019 with effect from 1/1/2020. With effect from 1/1/2020 for a period of almost 2.5 years, we didn't get any DA. Then, my lord, there has been small driblets of a minuscule percentage which has been given to us as a dearness allowance, which is why, my lord, it is important to state the point that, my lord, this is not gratis. This idea that dearness allowance is something which is gratuitous is
The methodology is the same.
method exactly
2006 to 2008,
yes,
nothing was paid.
exactly.
Again, 2019 to 21,
I'm grateful.
nothing was paid.
Exactly, my lord, this is the point.
They are saving it
Yes,
like old days money lenders.
and my lord, I
And the
couldn't.
businessmen
Yes.
use the money
Yes.
given to others
Yes,
for their own business.
my lord, for 2 years not to pay you from 1st of April 2008 and give you in driblets. That is, my lord, what was given in 1st of January 2006, you're making available to me in 2008. So, my lord, this is the real case.
Perhaps you can, let us know.
Yes,
The counter affidavit filed by
responded to.
page 16 and page 31. These are documents of the year 2022
Yes.
and 2020. Is there any document available there on record, or perhaps you can place?
Well, may I just search the record and give you a
What transpired?
yes.
We are interested to know between the period 2009 and 2009.
Yes, 2009 up to 19.
That would be. You may not answer immediately.
I'll just yes, certainly.
My lords, we do actually have it.
That was reflection there.
We know that, but we just want to. Just look into it.
Yes, we'll do that. My lords, we have it.
If you don't have it on record, doesn't matter. You can still give it to us.
Certainly,
It's on
but we
record.
just differently.
Because the cost of living in these two cities
Yes.
is obviously high.
Yes.
Malone, let us. That is true, Malone. But then they are state government. But the point is slightly different. The point is, Malone, 3C3 contemplates a determination. That determination, Malone, has also been worked out. What I'm trying to say is, it is not that there was only one way they understood this rule. It is not that they understood this rule only in the way it has been preached to us, namely that it was frozen and I have discretion thereafter to give you what I can and when I can. They, in respect of these employees, in terms of both the working of the formula under 3C3 and the time for which they gave it, this extensive period of time, until Malone finally the tribunal said this is discriminatory and the High Court struck it down. My friend said we have not appealed against that portion of that order. Fair enough, but the fact remains, we are looking at a period, Malone, which is up to 31st of December 2019. That period cannot be effaced. The period from 1st of April 2008 to 31/12/2019, which is covered by the ROPA rules of 2009, this persisted right through. And if it persisted right through, it is below a circumstance to take into account that is it really possible that the state government did not know how to work out, shall we say, the dearness allowance payable. And Malone, it is also not their case that this dearness allowance which they gave to these employees in Bonga Bhavan and these are not based upon the working of that 530, 539, 536. It is also not their case, Malone. It is not a case that they have adopted a formula, central government, but the point is, at no place, Malone, has the state said that if you calculate appropriately in accordance with the All India Consumer Price Index, IW, the result of the government, it is a matter of status governed by the rules.
Can you,
And, sorry.
sorry to disturb you.
No, Malone. I was just telling my learned friend, I think it's after quite a few years, we've seen two advocates general, eminent advocates general, Malone, sitting and adorning the bench in this court. It's after quite some time. Malone.
Can you show us the language of the central revision of payrolls?
Central revision. Yes, certainly.
ROFA of existing emolument
That's right.
excludes application of AICPI,
That's right.
according to them.
Which is why I wanted to show you, Malone, this rule itself.